Good evening and welcome. It's wonderful to see so many of you here this evening. I'm John Armour, the Dean of the Law Faculty, and I have the great pleasure of introducing our lecturer, the Right Honourable Lord Philip Sales. As you all know, Philip is a Justice of the Supreme Court who sat in many of the most important constitutional law cases of the past decade. I'm sure many of you also know that his contributions to the law have included an enormous amount of extrajudicial writing published in the very best law journal. You'll be aware of his work because you engage with it in your research or your studies, as the case may be. You may not be so aware, however, of just how broadly shared that experience of engagement with his work is. Such is the breadth of his expertise and impact as both a judge and a scholar, far broader than the range across which most of us specialise. Indeed, he is a Renaissance judge. Philip read law as an undergraduate at Churchill College, Cambridge. The following year, he came to Oxford to read for the BCL at Worcester College. He was called to the bar in 1985 and took up a tenancy at 11 Kingsbench Walk. His practice began in the field of employment law, but it soon diversified into more commercial and chancery work. This enabled him to develop a deep expertise across most aspects of private law. Alongside this, he found time to write on some of the thornier issues in private law, such as the relationship between contract and restitution and the tort of conspiracy. Despite the private law focus of his practice in the first decade or so at the bar, he retained a strong interest in public law. It was this interest which led him to accept appointment as the first junior Treasury Counsel, known as the Treasury Devil, in 1997, at the remarkable age of only 35. As Treasury Devil, he represented the UK government in the civil courts, and through his work in this role, he attained an exceptional range of insight into questions of public law. This was a fecund time for the development of public law. The Blair government had just come to power with its huge majority and a mandate for constitutional change. Two of the biggest changes were the Human Rights Act and the devolution of legislative powers. These threw up many groundbreaking constitutional questions in which Philip represented the government in litigation. It was also a very busy period in his academic writing, with an astonishing range of output that I think almost single-handedly kept the journal Judicial Review in press. Perhaps his best-known contribution at the time concerned the scepticism he thought it appropriate for courts to display when asked to review an exercise of administrative discretion on the basis of a substantive legitimate expectation, which he argued amounted to a very significant interference with the public authority's exercise of its judgment as to where the public interest lies for the time being. While traditionally the Treasury Devil would be appointed directly to the bench, Philip's career marked a departure from this when he took Silk in 2006. This necessitated a new name for the role, becoming First Treasury Counsel Common Law. He was, however, already undertaking some judicial work, having started to serve as a Deputy High Court Judge in 2004. As was surely anticipated by all, except perhaps Philip in his modesty, he was appointed to the High Court full-time in 2008. This was an unusual appointment. Philip was appointed to the Chancery Division because of his background in practice in Chancery work, but he offered to use his public law experience to do judicial review work in the Queen's Bench Division. He also served as a member of the Competition Appeal Tribunal from 2008 to 2015. During this period, I helped organise a conference about the judicial role in corporate law, at which we ran paired panels of judges from Delaware, the preeminent state court in corporate law in the US, and English Chancery judges. Philip was one of those Chancery judges. I raise this simply to underline the breadth of the fields on which he speaks with gravitas. We discussed in that context his judgment in the 2012 case of F&C Alternative Investments and Barthélemy, in which he gave a searingly clear analysis of the role of fiduciary duties in a private constitutional context, the governing agreement of a business organisation created under the Limited Liability Partnerships Act 2000. Philip's rise within the judiciary was rapid, appointed to the Court of Appeal in 2014 and to the Supreme Court in 2019. Along the way, he featured in both the Miller decisions and on the notorious Daily Mail front page. His academic writing has continued unabated. This has spanned the full range of his career interests. Private law has featured as keynote lectures on proprietary estoppel and the interface between contract and equity. In recent work, he's made notable contributions about the relationship between the deference shown by courts to public authorities under the Wednesbury unreasonableness doctrine, and that's shown by expert decision makers entrusted with fiduciary power under private constitutions, such as a company's articles of association or a trust deed. But perhaps the strongest and most profound theme in his work has been the Constitution. In a series of important papers stretching back to his time as Treasury Devil, he's thoughtfully articulated and developed his views on the relationship between the various key players or agents in our Constitution. And this is why I'm so glad that he's agreed to give this year's Clarendon Lectures in Law on the topic of constitutional agency. These lectures, which are traditionally subsequently published as a short book, will give him the opportunity to expound a full account. I'm especially glad that Philip has agreed to speak on this topic in this year, because needless to say, it is a time when understanding the workings of constitutional agency is especially important to every one of us. This is the first of 3 lectures. The other 2 will be held at the same time tomorrow and on Monday in the same venue. After tonight's lecture, there will be a few minutes for questions, which I will moderate. We'll then move to a drinks reception outside. I'd like to take this opportunity to thank OUP for their generous support for the Clarendon Lectures. Ladies and gentlemen, please welcome the Right Honourable Lord Philip Sales, the Clarendon Lecturer in Law of 2025.
Good evening, and thank you very much for coming to see the lecture this evening. The title for this series of lectures is deliberately ambiguous. I want to look at the constitutional agency of the executive, the legislature, and the courts. My focus is on the United Kingdom institutions rather than the devolved institutions. But what does constitutional agency mean? It has a double aspect. On the one hand, I propose to examine the agency that the Constitution creates for each of these institutions. On the other, I propose to examine the agency they have in terms of being able to modify the Constitution. What does it mean to talk about the Constitution in the context of the law of the United Kingdom, focusing in particular on the law of England and Wales? The UK does not have a single comprehensive constitutional document which can act as the reference point to identify constitutional issues. I'm not seeking to use the term constitutional in that sort of precise way, but rather to indicate an area of law and political practice where decisions are made which are of particular prominence and importance for the allocation of decision-making authority in relation to the exercise of public power, as between executive, legislature, and courts. In this sense, constitutional law shades into ordinary administrative law. Also, there are areas of constitutional law and practice which exist but only rarely come before the courts. Gillian Peele provides a schema for assessing constitutions. She points to the importance of political culture in their operation. I quote, "The complex set of values, attitudes, and assumptions, political prejudices and practices that interact with the more formal elements of a constitutional system." Political culture is particularly important in the case of the UK, in view of its lack of a comprehensive written constitutional document, and in consequence, a certain lack of clear positive rules of constitutional law. The principal points Peele emphasises about political culture are the extent of consensus within the polity, the role of the judiciary and the modes of legal argument, the character of constitutional argument, attitudes towards the state, the attitude of the media, and procedures for constitutional change. Peele observes that the particular mix of modes of argument which will command legitimacy is not something which is cut and dried or can be nicely measured. It reflects the nuances of a legal culture and the varying weight placed on such values as equality, procedural justice, and fairness, as well as broad assumptions of social policy. The fact that a court may appeal to a variety of values in the wider society, and that the particular mix that will give it legitimacy may change with the passage of time, is then one which makes it necessary to look beyond formal legal doctrines for an understanding of how courts interact with the polity. I close quotes. The state is dependent on the support of those subject to it. It needs to exercise power in a way which meets what Bernard Williams called the basic legitimation demand. Sources of legitimacy are varied and may fluctuate and change as circumstances and the expectations and the demands of citizens change in response. Giving citizens voice through democratic processes and the ability to enforce their rights in court may be an important basis for securing legitimacy for the state and its laws. The UK is aptly described as a liberal democracy. The liberal element refers to the liberty and autonomy which the political order is supposed to achieve for individuals. The democratic element refers to self-government and collective autonomy. The liberal element is the area of protection of individual rights under the rule of law. The democratic element relates to lawmaking in Parliament, the area protected by the principle of the sovereignty of Parliament. At the heart of the UK Constitution is the tension between these two elements. One of the principal objects of the Constitution is to achieve a stable, reasonable, and acceptable integration of these elements. But it also needs to secure a state which has authority to act and is effective in acting. That is the area where the executive needs to have agency. The conceptual foundations of this series of lectures are located in the work of Montesquieu, Arthur Venn Dicey, and Frederick Maitland. My debt to Maitland will be obvious at various points. From Montesquieu, I take the basic tripartite division of the constitutional order into the executive, the legislature, and the courts. This division has provided a helpful general organizing framework which has stood the test of time, capable of accommodating the different legitimation needs of a modern liberal democratic state, namely respect for the democratic principle, the legislature, for a principle of effective state action, the executive, and for the principle of the rule of law, the courts. Although that division was inaccurate as a description of Britain's polity at the time Montesquieu was writing, and remains so to some degree, it maps out distinct paradigm functions of the modern state and has proved remarkably resilient. Dicey's account of the UK's constitutional law in his Introduction to the Study of the Law of the Constitution has also been extensively criticised and cannot be supported in all its details. But in its essentials, it too has proved remarkably resilient. I contend that it continues to provide us with important insights into the structure and operation of the UK's constitution. Dicey's identification of parliamentary sovereignty and the rule of law as the two fundamental pillars of the constitution maps onto the basic feature of the UK as a liberal democratic polity, seeking to give effect to the principle of collective self-government and the principle of individual liberty. The third part of his book is concerned with conventions, the aspect of the British Constitution concerning constitutional or political ethics, as distinct from legal rules enforceable by the courts. In the late 19th and early 20th centuries, the political morality element of the Constitution was thick and broadly effective as a constraint on the exercise of power. As Neville Johnson explains, quotes, "The efficient secret of the Constitution lay in the fact that through its institutions and practices, it expressed a capacity held to be inherent in the society and its ruling elites to make those institutions work, to devise practical solutions to the problems of governing in a rapidly changing society and an expanding overseas empire, and to give stability to the future by sustaining habits and conventions of civilized social and political life." End quote. This third pillar of the UK's constitution continues to be important, but it does not have the same force as before. I will discuss the interaction between these pillars in these lectures. It has changed over time. Changes in the functioning and effect of each pillar puts political pressure on the constitution, and that in turn potentially generates changes in constitutional doctrine. Those changes in the relationship between the pillars and in constitutional doctrine have implications for the constitutional agency of the executive, parliament, and the courts, in both the senses that I'm using that term. They affect what each of them is authorized to do by the Constitution. They also give rise to questions about which element of the Constitution, parliament, executive, or courts, has the responsibility and capacity to respond in terms of doctrine and practice to a changing world, in order to allow the Constitution to maintain its acceptability in the eyes of the public and hence its stability. The executive has great power under the Constitution, but it is accountable to Parliament and through Parliament to the public. This control is the foundation for responsive and responsible government. Ultimate political control through accountability to the electorate at elections. That form of control also extends in certain ways to the period before election time. Anxiety about what the electorate is thinking of policies enacted in the life of a parliament affects political behaviour and calculation. Thank you. However, by virtue of the first past the post electoral system, which tends to lead to clear and decisive parliamentary majorities, and the discipline of the party system, the executive's control over Parliament has grown. At the same time, old patterns of self-restraint and customary norms of political morality have become eroded. Attempts have been made to respond to this within Parliament through enhancement of the select committee system, but the changes also pose challenges for the courts. If control of executive power through the political system is weakened, does that call for a turn to more legal controls to be enforced by the courts? And if so, is it Parliament or the courts, or both, which have responsibility to fashion a response? Alongside these changes, the increase in the 20th century of what was expected of the state in terms of the protections it would provide for its citizens in relation to health, security and welfare, and the democratic incentive for governments to respond to this, created a greatly expanded administrative state. In consequence, as well as acquiring enhanced power in relation to Parliament, the executive has acquired greater power over the lives of citizens at the interface between state and society. That too has called for a response in terms of public law doctrine to ensure that the exercise of that power is subject to adequate and appropriate control. The Human Rights Act of 1998 has been part of Parliament's response. Development of the common law of judicial review and the principle of legality has been a response by the courts. Both have posed their own challenges in terms of integration with the democratic principle and the constitutional principle of the sovereignty of Parliament. There are no fixed natural principles governing the organisation of a liberal democratic polity. The emergence of such a polity is a matter of contingency and relatively stable political compromise. Raymond Geuss, for example, argues that the component elements of liberal democracy harbour important internal contradictions, for instance, between different conceptions of democracy, and also are in tension with each other. The rule of law, for instance, is ultimately difficult to reconcile in full with the discretion inhering in the executive and its ability to react speedily to events, which is an inevitable part of governing. In a similar way, John Donne emphasizes the tension between democracy and the rule of law. These are not principles which find a natural point of reconciliation. They support different claims and different values, and the balance between them is arrived at by compromise within particular political systems. John Gray seeks to dethrone an Enlightenment view of liberalism as a natural order based on rationality, and argues instead for a view of liberalism as a modus vivendi, a form of life which in practice succeeds in accommodating competing values in ways which are acceptable and stable in local terms. And it seems to me that is a theoretical perspective well suited to analysis of the UK Constitution. As Maitland observed, quotes, "The Constitution is largely defined by those institutions and practices which emerged from and were confirmed as acceptable conclusions, facilitating renewal of constructive political activity after phases of acute conflict and division." End quote. There is no foundational written constitutional in the UK, so the legal rules which can be counted as constitutional tend to be more in the nature of general principles which, at certain points, achieve sufficient solidity to be enforced as legal norms. There is no specific body of law which is clearly demarcated as constitutional. Viewed as an aspect of the public law of the state, constitutional law in the UK tends to emerge from aspects of administrative law, which is the law which has the main role in determining the powers and responsibilities of public authorities and the conditions which they have to fulfill in terms of respecting citizens' rights when taking decisions. But at the same time, there are statutory texts with constitutional significance. These are studied throughout the regime of administrative and constitutional law and are capable of producing concrete legal effects. British constitutional values have in turn been informed by important texts and the assimilation of statutory reforms within a common law system. These texts include Magna Carta, the legislation to exclude papal jurisdiction in the 16th century, the Petition of Right of 1628, the Act to abolish Star Chamber, the habeas corpus legislation, the Bill of Rights of 1689, the Act of Union of 1707, and the Great Reform Act of 1832, and the expansion of the franchise thereafter. Elements of constitutional law can be identified in the common law, in statute, in the way statute is embedded in and interacts with the common law, and in the prerogative and other forms of executive power. The significance of the written-unwritten distinction should not be exaggerated. There is a range of written instruments which have constitutional significance, and codified systems also depend on custom and convention. For this reason, Neville Johnson emphasizes other features of the British Constitution which tend to make it distinctive. It is customary, conventional, traditional, and informal. In general terms, I would argue that the most satisfactory account of how the principles of collective self-determination and individual autonomy fit together in a way which respects the value inherent in each of them is to regard the protection of individual rights as the foundation for genuine formation of a collective will which is worthy of respect. In this way, political authority can be said to flow upwards from the people. John Dewey said, quotes, "Majority rule, just as majority rule, is as foolish as its critics charge it with being, but it is never merely majority rule. As a practical politician, Samuel J. Tilden said a long time ago, the means by which a majority comes to be a majority is the most important thing. Antecedent debates, modification of views to meet the opinions of minorities, the relative satisfaction given to the latter by the fact that it has had a chance and that next time it may be successful in becoming a majority. The essential need, in other words, is the improvement of the methods and conditions of debate, discussion, and persuasion. That is the problem of the public." Close quotes. There is another aspect of the problem of the public, or the defense of the Constitution, which should also be emphasized. That is how the Constitution can be framed in terms which inspire loyalty and emotional attachment on the part of the public. In an interesting article entitled "Sovereignty and the Persistence of the Aesthetic," Ilan Wall and Daniel Matthews argue that there is an important aesthetic dimension to the construction of sovereignty of a legal order, alongside political and legal elements. I would call it the emotional dimension of loyalty to the Constitution. Any constitutional order requires an element of emotional resonance to sustain public support for it. Judge Learned Hand made this point with force in relation to the US Constitution. He said, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it." Close quotes. The need to find a focus for emotional support for the constitutional order is particularly important in the case of the UK, which does not have a constitutional instrument like the US Constitution to serve as a focus for loyalty and public attachment. Instead, the UK Constitution has to inspire loyalty through a sense that it meets public needs in terms of protection of individual interests, including by allowing fair opportunity for participation in the exercise of political control through the electoral system, and to vindicate individual rights by going to court. There is also a need to seek emotional resonance in identifying its underlying value in an ethic of liberty, both at the individual and the collective level. An historical sense that the UK's constitutional order has been successful in giving effect to that ethic over a long time and enabled the country to survive and thrive in a world of challenges will also be significant. And I will return to this in my final lecture. In a discussion of the political thought of Hannah Arendt, Christian Volk argues for a conception of the Constitution which includes both law and politics without assigning primacy to either of them. According to Arendt, a third element is also required. On this account, the triad of constitutionalism is law, politics, and a reliable political order. A reliable political order cannot be realized permanently through law made by an administrative and judicial elite, separated from the processes of formation of public opinion and political action, because citizens will feel alienated from this and will be deprived of political experience, making them vulnerable to populism and authoritarian politics. On the other hand, a Rousseauian view of the primacy of politics undermines individual rights and jeopardizes the reliability, predictability, and stability of the political order. Law and politics on this account are interrelated, and each must take the requirements of the other sphere into consideration. The structure of order enables joint effort in political action, not through fixed pre-political rights, but as norms which originate in and are experienced as intrinsic to political action. One needs both law and politics to realize the multiple goods which a constitution seeks to promote, and because, as Volk puts it, to uphold a democratic polity is only possible through experiencing political acting. In Arendt's view, political power is only formed at the moment of action between people, and it disintegrates if they do not act together. In the light of this discussion, I've offered this formulation. A constitution is not just concerned to ensure that individual rights are protected. Its primary function is to generate authority which can be regarded as legitimate. Each of the executive, parliament, and the courts provides mutual reinforcement for each other, as well as fulfilling its own particular function. An efficient executive provides effective government and ensures the implementation of the policy commitments decided upon by Parliament and the rulings of the courts. The decisions made by Parliament and the courts legitimise the direct exercise of power by the executive. Legislation by Parliament provides a framework of law for the courts to apply, thereby giving effect to choices made by democratic means. And the courts safeguard the conditions under which public opinion comes to be formed and democratic procedures reflect genuine and free consent of citizens. Within this picture, an active and effective executive arm is an essential part. Authority will count for nothing, and the political order will lose its legitimacy if decisions taken within it are not implemented. Francis Fukuyama outlines the threat of political decay in the United States as it becomes what he calls a vetocracy, in which checks and balances in the system create too many veto points, and the capacity of the state for effective action is undermined. Fukuyama argues that constitutional design should be at least as much concerned with the creation of authority and the accumulation of power as with the limitation of authority and the division of power. He quotes Alexander Hamilton, "Energy in the executive is a leading character in the definition of good government. It is essential to the protection of the community against foreign attacks. It is not less essential to the steady administration of the laws. A feeble execution is but another phrase for a bad execution, and a government ill executed, whatever it may be in theory, must be, in practice, bad government." Jack Balkin makes a similar point. Government must be sufficiently effective to maintain security and social peace, and sufficiently just to be deserving of cooperative engagement by citizens. The effectiveness of government is linked to the capacity of the executive to respond speedily to unfolding events. As Geuss puts it, politics is in part about dealing with the unexpected, and one of the points of having public officials and the government at all is to allow them to respond quickly and flexibly to urgent matters that have not been anticipated. The ability of the governance regime to provide a safe and reliable political and social order and to give practical effect to legal and political decisions taken according to proper procedures is an important foundation for the legitimacy of the governance system itself. As Tony Judt writes in Post-War, his history of Europe after the Second World War, keeping systems safe is what states do. Legitimacy is a function of capacity. And writing in the same vein, John Donne says, there is a need on the part of its subjects to which sovereignty answers. Above all, the need to establish and sustain a framework within which they can hope to live securely. The ability to provide security and effective government is sometimes referred to as output legitimacy. Therefore, legal rules preserving freedom of action for the executive can be as important as legal rules which impose positive duties on them. In the light of this discussion, I turn to address the role of the executive in the governance system of the UK. The executive is the body charged with carrying on the government of the state in a fast-paced and changing world. It is constituted as a set of complex departments and bodies. It has the task of ruling, subject to the allocation of legislative functions to Parliament and judicial functions to the courts. The executive attracts the attention of practicing and academic lawyers less than Parliament and the courts, which are focused on the making and interpretation of the law. The focus of the executive is on ruling in a wider sense, but to understand how the Constitution works, it is important to give it at least equal importance. The executive is central to the operation of the constitutional order through its control of parliamentary business and the legislative process, its authority to make the fundamental choices for the state regarding raising taxes and deploying state resources, and through its power of day-to-day rule. The executive is responsive to democratic inputs through the need to win national elections and to command a majority in the House of Commons. it commands the civil service, which is the repository for expertise within the governance system and has responsibility for the implementation of policy. The executive government is responsible for the conduct of international relations and for managing the interface between international law and domestic law. It also has an extensive lawmaking function through the promulgation of subordinate legislation. Therefore, the executive's active agency is at the heart of making the governance system work as a vibrant and responsive liberal democratic order. The executive government is intimately bound up with control by Parliament, but also control of Parliament. Ministers have to be members of Parliament and are accountable to Parliament. The Prime Minister has to be able to command the confidence of a majority of MPs in the House of Commons, and he or she and their government is removable on a vote of no confidence. This is important as a potential safety valve to remove the government if it becomes seriously unpopular. But party discipline means that it is unlikely to be used where the governing party has a significant majority of MPs. Accountability to and removable by Parliament is the Constitution's primary mechanism to promote responsible government. The government must respond to MPs' concerns, and MPs will be responsive to the concerns of their constituents. At the same time, command of a majority in the House of Commons gives the executive a large measure of control over the activity of Parliament. It enables the executive to use Parliament as a tool of government. It gives the executive the means to create law in its highest form, that is, primary legislation. In the light of the basic legitimation demand in the modern state, law is a primary response for effective government, and the ability to create new law is fundamental. Moreover, it has been observed that the executive's right of initiative in relation to both taxes and spending makes it the partner, not the subordinate, of Parliament. The executive is plural in nature and has a wide variety of functions, reflecting the multifarious demands upon the state. It is not as such a legal person or a subject granted legal powers. In the Town Investments case, Lord Simon said that the term the executive is barely known to the law. Maitland wrote that the executive is not, quote, a legal organisation. Of course, I do not mean it is an illegal organisation. Rather, I should prefer to say it is an extra-legal organisation. The law does not condemn it, but it does not recognise it, knows nothing about it. As we will see, that requires some modification these days. The complex concept of the Crown does some work to give a degree of legal form to the executive government on the theory that the Crown is an abstraction of the monarch who acts on the advice of his ministers. But in reality, the executive is a political concept. Most of its legal powers are conferred by statute on the Secretary of State, each of whom heads a distinct department. Coordination is achieved and coherence given to executive action through political control via the Cabinet as a committee of ministers chaired by the Prime Minister. Accordingly, an important dimension of the constitutional significance of what the executive does is this coordination effort through its own internal measures to stabilise and control the powers and discretions granted to it by the law. This is a subject explored by Daintieth and Page in their book The Executive in the Constitution. They explained that the United Kingdom executive is more plural than unitary. The functions of modern government have been laid not on the executive as a whole, but on a heterogeneous collection of ministers, officers, and authorities exercising a mass of apparently unrelated miscellaneous functions. Daintieth and Page explain how coherent coordination is achieved in relation to such fundamental matters as how government secures money supply from Parliament, how the executive is central to the distribution of funds voted for its use, and how in practical terms it seeks to ensure through Treasury control that spending by government departments is directed to proper ends and is accounted for. The government has extensive control over the parliamentary procedure in relation to money bills, and the Treasury has considerable powers of control in relation to the use of funds by departments. The flexibility of these procedures means that the executive is able to adjust them very easily to take account of changing demands upon the system. The internal control of the executive over itself is distinct from the external control through political mechanisms, that's the discipline of elections and parliamentary controls, and legal mechanisms, that is control by the courts through judicial review. It is very important since Parliament and the courts do not have the capacity for continuous supervision of government. In consequence, the effectiveness with which the values of democratic accountability and of legality are implemented in the British system depends in large measure upon the executives being so organised and controlled as to achieve those ends. In exercising control over itself, the executive is a source of normative direction and the guardian of values which serve the ends of democratic control and the rule of law. This is done by a combination of rules laid down by the centre and by inculcating an official culture which, whilst particular to each department, looks to the centre for guidance. Through internal control, the executive transforms its powers and discretions into stable rules and procedures for deploying the resources of government. Those rules and procedures are themselves an important part of constitutional law and practice. One constitutional boundary that has not emerged is between the political executive and the professional or expert executive. In the UK's constitution, the executive has a dual role. On the one hand, it emerges from Parliament as the government is selected by the majority party, elected on the basis of a manifesto presented to the public. This governing group has responsibility for dealing with the public finances, for the management of public affairs, and for initiating legislation. It is the active element of the democratic principle, selected and maintained in power through the political process. On the other hand, the executive is also the body which has access to the expertise of a professional cadre of civil servants maintained by the state and necessary for the effective fulfilment of a wide range of state functions. According to constitutional theory, this civil service exists as a neutral body which is in place to carry out the directions of the political executive. It has not achieved an independent status of its own, giving it a distinct legal standing or power of resistance against the political executive. Instead, the executive is treated by the courts as one undifferentiated whole, represented in a typical case by a Secretary of State at the head of a government department, which has authority to act based on a combination of the democratic principle and a principle of professional expertise. This dual character of the executive, as authorised through the democratic process to exercise political power and as expert, is increasingly reflected in the contours of the law as articulated by the courts in terms of the separation of powers. I will return to this in my final lecture on the constitutional agency exercised by the courts. The strict legal control of tax and spending by Parliament, pursuant to the initiative of the government acting by the Treasury, and these various mechanisms of supervision by the executive and Parliament are the foundation for democratic control of taxation and spending. Treasury control of spending is one of the primary means by which the executive both pursues its own functional objectives and upholds democratic values by ensuring that funds provided by Parliament are properly spent on the purposes intended by Parliament. Control of tax and spending is also the practical material foundation for the legal doctrine of parliamentary sovereignty. It is difficult to see how that doctrine could prevail in the long run if Parliament did not have control of these fundamental aspects of state activity and power. 6 points may be made by way of an overview. First, the executive, in the form of the government of the day, is central to the operation of Parliament and the democratic system more generally. In order to become the government, a party has to garner support at elections by presenting the electorate with a programme of government and legislation. Then it has to be able to secure and maintain the confidence of a majority of MPs in Parliament. Secondly, and in consequence of its command of a majority in Parliament, in ordinary circumstances, the government controls business in Parliament. Legislative time in Parliament is a limited resource. The executive has to have in place procedures to determine how this resource is used. Parliament is, in fact, a vehicle for government just as much as it is a legislature. The government uses it as a theatre for promoting, providing a public focus for, and debating its wider governmental initiatives. Government is also substantially in control of the legislative programme to be presented in Parliament. This programme is presented in the King's Speech at the start of each session of Parliament. The government has its own department of specialist drafters of legislation, the Office of Parliamentary Counsel. They take instructions from government departments and produce detailed legislative text to implement policy initiatives in the form of law to be enacted by Parliament. Thirdly, the government is, through its control of Parliament, responsible for the public finances. Its role in Parliament is central to this. Taxes can only be raised pursuant to legislative provisions. sums can only be paid out of central funds with the authority of primary legislation. Government, through its control of the legislative process, is also responsible for adjusting legal duties imposed on public authorities, compliance with which implies financial expense, with the funding available from taxation. The implications of this are profound. It means that it is the executive which is responsible for managing a sort of legal black hole or conceptual chasm at the heart of the Constitution. Legislation imposes duties on public authorities with varying degrees of specificity as to the entitlements created under it. But the imposition of a duty does not in itself carry the financial resources needed to meet it. There is a spectrum of duties ranging from precise, quantified entitlements in specified circumstances, with no flexibility on the part of the relevant public authority regarding matching its financial resources with the payments to be made, through duties which are more open-textured in form, which allow a degree of flexibility for the relevant public authority to take into account the resources available to it when deciding how to fulfill its obligations, to so-called target duties, which involve no specific legal liability for the public authority if it fails to find the resources to provide the services specified. The marrying up of legal duties and the financial resources required to comply with them, which is a matter at the heart of the due operation of the Constitution, is thus, in essence, a matter for which the executive is responsible. It has the means to seek legislation to adjust the duty side of the equation, whether by imposing or reducing duties, and it is responsible for obtaining through taxation legislation and through the appropriation and funds allocation process the financial resources needed to satisfy the duties. It is through the exercise of executive powers and discretions that the legal gap between duty and funding is bridged. Fourthly, in a state which respects the rule of law, the executive is subject to the interpretation of the law given by the courts. But that subordination of the executive to the courts is moderated through the executive's control of Parliament. In theory, if the executive cannot live with a ruling of the courts, it can seek to modify the law by introducing and passing legislation in Parliament. But as Daintiff and Page point out, this course has costs for the government in terms of use of scarce legislative time and political cost. And this means that in practice, the executive has to recognise that the courts are a serious partner in the operation of the administration, and accordingly has to take account of the distinct rule of law values which they promote. Fifthly, the executive implements and enforces the law as laid down by Parliament and the courts. It is itself subject to and required properly to adhere to the legal rules laid down by them. Hence, the executive's internal processes for taking legal advice and disseminating it are far more important than the sporadic incidents of judicial review by the courts for practical adherence to the rule of law on the ground in the myriad situations and thousands of cases the executive has to deal with day in, day out. Sixthly, by implementing the law and providing public services in an effective way, the executive provides output legitimacy and hence reinforces the overall legitimacy of the Constitution in a vital way. Also, the civil service supplies an element of legitimacy through expertise in the management of state affairs. It also provides stability in the formation and delivery of policy over time, counterbalancing to some degree the vicissitudes of democratic politics. However, for reasons to do with the culture of the British civil service, as analysed by Daintiff and Page, it might still be said that the executive is better at policy formulation at the centre, rather than service delivery through its various agencies and other bodies dispersed through the governmental system. This leaves two other areas of executive action which are of particular constitutional significance: the conduct of international relations and management of the interface between international law and domestic law, and the executive as legislator through the promulgation of subordinate legislation. As regards the conduct of international relations, as the first Miller case highlighted, the executive retains an important function in managing the UK's foreign relations and entering into treaties. In an increasingly interconnected world, where coordinated actions across governments are called for to address problems with international dimensions such as climate change and international security, these are important powers. Moreover, the executive is central to managing the interface between the UK's international obligations and its internal domestic legal order. If the executive negotiates treaty obligations, it has to ensure that any legislation that is necessary to ensure the UK complies with those obligations is brought before Parliament and passed into law. If the UK has entered into a treaty and ratified it, the political pressure on Parliament to pass the necessary legislation may be high, so the power of initiative for the executive government in international relations is important. Tom Poole argues that modern states enjoy a sort of compound sovereignty in which they are nested within and increasingly both enabled and constrained by international law. As he puts it, while the capacity of the state to interact normally with other states is enhanced as a result of this development, its effective choice set when it comes to sovereign acts is more limited than it once was, when the juridical atmosphere that animated the state was thinner. So international and domestic law should be seen not as wholly distinct, but as overlapping and mutually reinforcing bodies of legal authority. It's the executive which actively manages this compound sovereignty, steering the state in its relations with others. The creation of subordinate or delegated legislation is another area of profound and growing importance in terms of the power wielded by the executive within the Constitution. There are substantial criticisms of the way in which lawmaking by subordinate legislation undermines parliamentary control, since the standard of scrutiny is low. Already in 1929, Lord Hewitt attacked the delegation of legislative power, but that attack did not lead to curtailment of that power. No government has cut back on this trend. Indeed, the transfer of legislative power to the executive has increased. The standard justifications for delegated legislation are that, first, use of delegated legislation is necessary because of the limits on parliamentary time for creating primary legislation. Second, use of delegated legislation may be necessary where it is desirable for laws to be drafted by reference to specialist expertise, which may more readily be available within a government department. And third, delegated legislation may more readily meet the need for flexibility and expedition on occasion in the interest of effective government. It also seems broadly desirable that big picture policy issues for legislation should usually be set out in primary legislation, debated in Parliament, and subject to amendment procedures in the usual way, whereas it is more appropriate for fine detail to be pushed down into delegated legislation. Further, it seems sensible to allow for different levels of oversight by Parliament of delegated legislation. This allows for more finely calibrated accommodations between democratic oversight by Parliament and the values promoted by use of delegated legislation and parliamentary time saving made possible by such use. This is what the various gradations of parliamentary oversight are designed to achieve, moving from the simple laying of some forms of delegated rules before Parliament, so that Parliament is afforded an opportunity to intervene if it chooses, through the negative resolution procedure and the affirmative resolution procedure, and on to the super-affirmative resolution procedure for certain kinds of delegated legislation. Should be noted that there has been a movement towards graduated parliamentary involvement at the level of primary legislation as well, with special truncated parliamentary procedures for certain kinds of uncontroversial legislation or legislation proposed by the Law Commission. All this makes it sound as though there is a coherent scheme which governs lawmaking and the relationship between primary and secondary legislation. The problem is that this scheme does not survive contact with the real world of politics. It appears that in reality there is very little effective parliamentary scrutiny. The principal reasons for this, I suggest, are threefold. First, there is the increase in governmental activity since the 19th century. Rule by central government has massively expanded due to the demands made on the state for welfare protection, provision of health services, management of the economy, management of various security risks, and so forth, as a result of the democratization of our political system. To this must be added the boost to centralization through the experience of 2 world wars. It's notable how even in the course of the 19th century, the form of legislation changed, with fewer and fewer acts of parliament to regulate purely local matters than had previously been the case. How much more so is that true in the 20th and 21st centuries? The second reason, which is connected with the first, is the limits on parliamentary time and the demands made on that limited time. The increase in the grant of powers to create subordinate legislation is a response to the fact that legislative time in Parliament is a highly constrained resource. The grant of these powers can be seen as a sort of safety valve to ensure that the executive can produce binding law to carry on governance, despite the existence of legislative hold-ups in taking primary legislation through an overburdened Parliament. Parliament is an instrument of government as well as a legislature. It is the site for political debate and theatre, providing a focus for democratic engagement and scrutiny. It is the place for important government announcements, for debate over government policy, for holding the government to account, and ultimately for testing the ability of governments to rule by holding votes of confidence. It's the hurly-burly of the political contest which, unsurprisingly, tends to capture the time and attention of politicians and the wider public, rather than the legal minutiae of legislation. And MPs' attention is most concentrated on legislation at those points where the legislation itself becomes the focus for more general public discussion and attention. None of this is wrong or necessarily bad. The profile and focus which the more theatrical elements of politics give to public debate regarding the general policy direction of government are an important concomitant of an effectively functioning representative democracy. They provide a salient demonstration of what is being done in society's name and help connect public opinion to the political and lawmaking process. They assist the formation of public opinion into coherent patterns, stable across time, which in turn provide guidance for politicians in offering policy solutions, standard against which their performance in serving the public can be judged, and degree of transparency for the public to monitor the performance of their representatives. But they do take up parliamentary time. The third reason is the basic point made by Daintiff and Page about the importance of law as a resource of government in a state which is subject to the rule of law. Government needs law in order to govern legitimately and hence effectively. So although the abstract scheme for graduated parliamentary scrutiny and control of delegated legislation seems coherent enough, it does not work well in practice. The different grades of parliamentary oversight do not seem to act as triggers for increasing levels of scrutiny. The impression given by the statistics is that there is close to being one level of scrutiny, which is none. Brexit has highlighted and compounded the problem. The parliamentary political theatre around this issue has sucked up large amounts of parliamentary time and is likely to continue to do so. It absorbs huge amounts of politicians' time and attention outside parliamentary procedures as they try to explain their competing visions and compete for public support. This is entirely understandable given the strategic importance of working out a new path forward for the country. Further, coming after years of cutting back government departments through sustained austerity policies, Brexit also put special strain on the limited resource of government to work out the detail of policy and give proper instructions for the drafting of primary legislation. The Office of Parliamentary Counsel, for example, which is responsible for the drafting of primary legislation, has been subject to significant cuts. Parliament itself plainly could not cope, in addition, with the huge amount of detailed and often technical legislation which is likely to be needed to achieve the unscrambling of the UK's laws from the EU's after a period of more than 40 years of their being increasingly entwined. Given the extent of the task of this unscrambling and its importance for providing legal stability and the predictability necessary for individuals and businesses to plan their affairs, the demand for legislation is great. The position is worse if proposals to make any changes to primary legislation are remotely controversial, as many measures for effective government have to be, because that would create an even greater demand for parliamentary time for the debate necessary to carry them through Parliament. The legislator, in the form of Parliament making primary legislation, is absent because the time and other resources needed for legislating are highly constrained and its attention is elsewhere. In addition to subordinate legislation, an increasingly important function of the executive is the promulgation of policies to explain how ministers will exercise broad discretionary powers granted to them by Parliament. The development of the doctrine of legitimate expectations means that these policies may have an effect bordering on the legislative by imposing defeasible legal obligations on decision makers. The promulgation of policies is not subject to parliamentary control, other than in the general sense that they might be criticised in Parliament in the same way that government can be criticised there for any of its activities. So here also, the executive's constitutional role appears to be expanding. So in conclusion, the constitutional role of the executive tends to be overlooked in the law books because a lot of that role does not involve law as such. But the executive has a good claim to be the most important body which exercises constitutional agency in both the senses I have mentioned. It provides the animating spirit of the Constitution. The executive government has a wealth of legal powers for action available to it under the prerogative, under the common law, and as conferred by statute. I will discuss the legal controls in relation to these in my third lecture on the constitutional agency exercised by the courts. These powers allow the executive to exercise constitutional agency of its own across a wide range. Most fundamentally, the executive is responsible for the active management of the implementation of the constitutional order. Central to this is its responsibility for managing taxation and spending through the formation of government policy, the obtaining of funds from Parliament, the matching of legal responsibilities of public bodies with the funds available to them, and ensuring that the funds provided are spent in accordance with Parliament's will. Finally, through its practical control of legislation in Parliament, the executive has the power to effect constitutional change of the most far-reaching kind. The enactment of the Human Rights Act is a prime example. So are the European Communities Act of 1972 and the EU Withdrawal Act of 2018. But this is agency exercised by the executive through and in partnership with Parliament. The constitutional agency exercised by Parliament and the courts must take account both of the power of the executive, but also its responsibilities and the need for it to be effective in what it does. Parliament's constitutional agency is the topic of my next lecture. Thank you very much.